everyone. I'm Sarah Buxton. Welcome to this evening's webinar. This is a series of webinars, and this one this evening is on practice management and HR essentials. I thought it was important to do this webinar tour because although we've all been caught up in COVID and the furlough scheme and now the job support scheme, and I'm sure we'll have lots of questions about that, and I'm more than happy to answer any queries that you may have. I think it's also important that we go back to and have a sound understanding of our obligations as an employer or manager in a dental practice. Each webinar is going to be slightly different and maybe a slightly different format, and we've got some guests coming on in a couple of weeks, so please make sure that you do attend the webinars again in the future. If you do put any questions and answers in the box below, I will keep those confidential. And if you'd like to use the chat box, then obviously that's open to most people, and it may be that your name is referred to. And I think it's important that I've said that at the beginning because there's been an awful lot on social media, and it's at the moment I'm dealing with quite a lot in practice where people are breaching confidentiality. So rule one, something that you need to know if you're dealing with staff is that confidentiality is of the utmost importance. That being the case, if you can identify who you're speaking about on Facebook in some of the groups, for example, then that can amount to a breach of confidentiality. So just be careful with what is being said on social media. It's much better to ask your queries in a forum such as this, and also you'll get the right answer. As it does worry me sometimes on Facebook when there's lots of people chipping in with their opinions, which is fine, but it's always not the current law and current legislation. Anyway, so let's get to it with practice management and HR essentials. You'll be aware in practice that one of the most important documents when you are employing staff is the employment contract. I still come across numerous practices where they do not have up-to-date employment contracts in place. I still see contracts that were drafted in 1972 and have never been touched, and that's because staff tend to be quite loyal in dental practices and they tend to remain in the practice for a long period of time. However, that doesn't mean that you're not under an obligation to make sure that the employment contract is updated, and usually on an annual basis. The reason why I say usually on an annual basis is because employment law changes so quickly that what was in the contract last year probably won't be sufficient to be in the contracts this year. And if you haven't done so already, one of the things that you will be looking to do, and don't get me wrong, I completely understand that there's been an awful lot to think about this year, and this is one of the last things that you'll be wanting to do, but you must ensure that you update your employment contracts. And that's because on the 6th of April this year, there was a change in the law and the Good Work Plan came into force. And it's really interesting because the Good Work Plan came about because of a report that was published into, for example, self-employed status, and whether people who claim to be self-employed are genuinely self-employed. And I'm going to come on to that later this evening. So going back to the Good Work Plan, the principles that you need to be aware of as a practice manager or employer in the dental practice that any judge would look at if you ended up in the employment tribunal, and that you should have as almost like core values in the practice are the following. Satisfaction, and it was identified that people need to be satisfied at work, because if you provided satisfaction as an employer or manager, then people would remain in their jobs, you would attract talent, and employees can then make better decisions about their own employment and so on. So always bear in mind satisfaction. Secondly, fair pay. So they really wanted to ensure that any unequal pay between gender is abolished, and ensure that everybody knows where they stand in terms of what they're being paid and why they're being paid that amount. Participation and progression. The government wanted to ensure that everyone had the basic skills to enter the labour market in the first place, and then once they were in the labour market, that as an employer or manager you would develop that individual and provide training, for example. Well-being, safety and security. So this is ensuring that the workplace is less stressful and more productive. And there was a huge emphasis when this came into force on mental health initiatives. I don't think, obviously when this is taking years to put into place, and they had no idea when they were drafting the Good Work Plan that we were going to have a pandemic, but it was already at the forefront of their minds how important mental health in the workplace is. And what I would say in respect of this is that at the moment I'm dealing with lots of sickness absence where people are claiming to be stressed or suffering from anxiety. And we will do a webinar in its own entirety on sickness absence and dealing with stress and anxiety and disabilities in the workplace, because it's a very full-on topic. But one of the things that you can be thinking about and should be thinking about as being one of your HR essentials is to ensure that you have a mental health first aider in the practice, because that will set you in good stead if there are any issues that arise in the future. And the final principle in respect to the Good Work Plan is voice and autonomy, and this is for the employee. So they wanted to ensure that the employee could be heard, and they did make some changes in respect of compensation and the employment tribunal and how that works to ensure that this was the case. So in respect of your employment contracts, with the Good Work Plan, the changes that came into force, which they feel as though satisfied those principles, were that the employment contract must be given on day one of employment. So previously you had up to 2 months to provide an employment contract, but the law now states that it must be provided on day one, and any failure to provide that employment contract on day one means that you can be fined if there was ever a claim to the employment tribunal. My advice would be to provide that employment contract with the offer letter. So when you are providing an offer of employment to an employee, you provide that offer conditional on a criteria that suits you and your practice. And you'll hear me say this a lot about what suits you and your practice, because each practice will be different in what they require for their team. So in respect to the offer letter, you would want an enhanced DBS check. You would want to see qualifications. It may be that you want to that they have to be registered with the GDC before they start with you, and one of those other conditions would be that they sign and provide the employment contract back to you. It's much easier to provide the employment contract at that stage where you're saying to them, I'm providing you with this offer, based on the fact that you sign this employment contract, rather than getting them into practice and then having to negotiate or trying to get a signed contract back from the individual. And I would always say, please do your best to ensure that you have a signed contract back. It's a HR essential, it's a top tip. It makes life so much easier if you have a signed and dated contract that both parties have agreed to. So some of the clauses that needed to be changed in accordance with the Good Work Plan, and somebody's just made a really good point, thank you, that in the conditions in the offer letter include references. So CQC will expect 2 satisfactory references and that should be part of the offer of employment. So really good point there that's just been raised. Thank you. So in the employment contract, the terms and conditions that you may not have had previously that came into force with the Good Work Plan are things that you need to consider if you've not already done so, making sure that they're included. And the first one of those is the probationary period. And it needs to include conditions for passing and the duration. And that's a really interesting one, because I think previously, if we use probationary periods, we wouldn't necessarily make it very clear if somebody had passed that probationary period or whether it was being extended. And that now needs to be set out in the contract, how they will know. So you will inform them by writing, for example, that they've succeeded at the 3 or 6 month probationary period. And the length varies. There's no set number of months that you have to have as a probationary period. Another detail that you have to include are details of any training entitlements and mandatory training, really important in the dental practice, and who is responsible for the costs. So if you expect your employees to undertake their own CPD at their own cost, then you need to make this very clear in the contract. If the practice pays for it, again, we need to make that very clear in the contract. If, for example, you are providing or paying for training which may be substantially more, such as you may be paying for a dental nursing course or hygiene course or something along those lines, then it may be that you will also want to include another clause on top of that, where if the employee leaves you within a certain amount of time, you can recoup those costs back. So what you don't want is to be paying for somebody's training and for them to go and work for your competitor, because you will be able to, in those circumstances, somebody else is reaping the rewards, basically, of what you've paid for. So it's really important that a clause is included. And for you to include that clause, you do need to be reasonable in the time period. So I have seen some clauses where they've said, if you leave me within the next 5 years, you'll have to pay back your CPD that we paid for you. And that probably wouldn't stand up in court because it's unreasonable. So you've got to be reasonable in terms of how long you right in terms of where recouping those costs back. And it may be that you take a staggered approach. So if they leave you within the first 6 months of the course, they may repay 100%. After the 6 month period for another 6 months, so within that latter half of the year, they owe you 50% of the course of the money back, and that's because you will have had some of the benefit of that training. Other clauses you may think sound a little bit funny, but the days of the week the employee is expected to work. Fairly straightforward if you have somebody who works Monday to Friday, 9 till 5, and you get that in the contract. But if we do have rotas in place, you still need to set out the hours and the days that you're expected them to work. And you do need to make it very clear, if you are using a rota, how that rota works. So I do come across contracts where it says you'll be expected to work 32 hours a week, but it doesn't set out between what times on and what days. So it needs to be a bit more structured, and I think that's where one of the key principles of fair pay and transparency and the employee being satisfied is coming through. And another one, quite a big one in terms of all benefits provided by the employer. So in terms of the benefits, this is any bonuses, any insurance schemes, any free dental treatment. Those are all benefits to the employee, and they now need to be cited in the employment contract. Really important that you do so. And one of the hardest things I'm finding when I'm drafting contracts for the client is that what you perceive to be something which is just part and parcel of being an employer, or being part of this dental team, as in giving free dental treatment. You may not see that as a benefit. You just feel as though it's a gesture, it's something nice to provide, but it is a benefit to the employee. And the reason why they want all this put in the contract is because if you end up in a tribunal claim, what happens is the employee creates a schedule of loss where they put down all their losses as a result of them losing their employment. And you'll be surprised how many times we see on there things like the Christmas bonus, the dental treatment that I should have been having that I'm not having anymore. So you must ensure that any benefit is included in the contract. And also, what you do want to do is make sure that they are discretionary, especially during the last 6 months that we've just been through. I'm not sure if there'll be many practices in a position where they can provide bonus, for example, but it may be that you have to provide that bonus if it's contractual. And the only way that we can make a bonus not contractual is to make it discretionary in the contract. So again, at the moment, I'm dealing with quite a few issues where the staff are saying, you owe me a bonus, and actually the practice owner or manager should be paying a bonus, even though the practice can't afford it, because it's contractual and you don't want to be in breach of contract. I've just had a question come through, so don't forget, if you do have any questions, do let me know in the question and answer box below. If staff want to do courses that they are not of direct benefit to the practice, are they still entitled to paid training leave to attend that course or exam? This will depend on the policy of the practice. In those circumstances, if somebody is wanting to do some training and it's not associated or connected to the practice, then you can provide them with, well, they can take annual leave or they can have unpaid leave. You should be encouraging training, because hopefully you would see the benefit of that. Hopefully there is some connection somewhere. But at the end of the day, you're under no obligation to provide them with paid training leave, unless that's the policy of the practice to do so. Just a few other clauses that I often find that are incorrect, and definitely a HR essential that you are on top of this and aware. In the contract, the name of the employer, it is not the name of the dental practice. That is a trading name. So the name of the employer in the employment contract will either be yourself as a sole practitioner, the partners, the expense sharing, the limited company. It is not the name of the practice. And if we end up in an employment tribunal, the first thing the judge looks at is the employment contract. And it doesn't look very good if you can't even get the name of your dental practice or the employer correct. So just bear that in mind. The trading name is not the employer. So really important that we do get that right. And I see that wrong on many occasions. Coupled with the employment contract, you should all have a staff handbook, and that will have numerous policies in there. And again, it will vary from practice to practice as to what the policies or procedures are that you have in the staff handbook. You don't have to provide a staff handbook to every member of staff. They just have to know where it is so that they can allocate that document. And some of the things that you will have in that staff handbook, which I always say should be non-contractual, is that, and the reason why I say that is so that you can easily change the staff handbook. If it's contractual, so part of the contract, you can't change it as easily. There are ways and means, but it's just not as easy when something becomes contractual. So, for example, I would say disciplinary and grievance policies all in your non-contractual staff handbook, not part of your contract of employment, because if you have to do a disciplinary or a grievance procedure and it's part of the contract and hence contractual, and you cannot follow that procedure, you end up being in breach of contract by not following that procedure, which is the last thing you want to do. If it's in the staff handbook and it's non-contractual, you can divert away from that policy. So to give you an example, if you were doing a disciplinary and the disciplinary policy said that you'd provide an outcome within 5 working days, and you couldn't provide that outcome within 5 working days because of annual leave or something happened, if it's part of the contract, you'd be in breach of contract. If it's in the staff handbook, you could easily just write to the employee and say, I can't provide an outcome within 5 days, I'll provide it within 10. So let's make sure that as many policies as possible are in the staff handbook, and don't just go and take the policies off the back of the contract because it still refers to them in some of these template contracts that you can download. So just be very careful when it comes to contracts, but as many policies as possible in a staff handbook. That's how I like to see it. And so we've just had a question here. What if a staff member refuses to sign a new contract? I would be asking why. So contracts, especially the employment contract, is meant to protect both parties. So what that means is that both parties have an understanding of the relationship. So it's in their benefit as much as it is in your benefit to sign the contract. So if they won't sign it, I'd want to know why. And if usually they probably won't sign it because of a lack of understanding, and then you'd have to try and explain to them what that clause means and why it means that. And this is why it's good to try and get them signed before they come into practice. But if you're changing them because you're updating them with the current legislation, they can't really moan about that because it's the law. You're not making fundamental changes. You're not changing their holiday, for example. All you're doing is being a good employer and bringing them up to date. So in that situation, I'd be sitting with the employee and going through the contract with them to make sure that they have a full understanding of what it is, and trying to get to the bottom of it, rather than them just saying, I'm not signing it, I'm not signing it, because that's just not constructive for anybody. And if they refuse to sign it, there are procedures you can go down. It's insubordinate, and so on. So we try and stay away from the formal procedures if we have to, because it's much better to go down the route of trying to get them on board. So someone's just said, what if you've taken over a practice and had the staff transferred via TUPE? So basically, most of you will be aware that TUPE is the Transfer of Undertakings Protection of Employment Regulations. And what that means is that if you buy a practice, the staff transfer across on the same conditions as they've always been on. That doesn't mean that you can't change their contracts. What it means is you can't take over that practice and go in and change their pay, or you can't go in and change their holiday entitlements. You can't do anything which is to a detriment. It does not mean that you cannot change their contracts. So in that situation, and the individual that's asked this question has gone on to say previously they've been used to a one-page A4, and they're looking at now comprehensive contracts and they're freaking out. It needs to be a conversation with them where you sit and say, look, I understand that this is scary, but let's go through it. Let's read it clause by clause so that you understand what we're doing and why we've done it. And that's really important. It's not enough just to be handing out contracts. It needs, and I would do it on a one-to-one basis as well. Make sure that you take them in on a one-to-one basis and make sure that you fully explain it to them. But don't think that just because you bought a practice that you can't make changes to terms and conditions. You can bring them up to date. Another question coming through. Sorry, so is it the good work plan to include in the contract? Yes, so what the good work plan did, which it introduced those principles into the workplace that I talked about at the start of the webinar. And as a result of that, the law changed, and those terms and conditions which we may not have included previously, such as details of benefits, probationary periods, days, how a rota works, now all have to be included in employment contracts. So all employment contracts need to be updated to ensure that they are in line with the good work plan. So back to the staff handbook. I've talked about disciplinary and grievance procedures. You will want a sickness absence procedure in there. And again, as I've said, we will come on to sickness in its own right, but it will be a webinar as part of this tour because it's a huge subject. And I appreciate that it's one of the things that you probably are dealing with a lot at the moment. So we will come on to that at some point. But what I would say is if you are dealing with any sickness in the practice at the moment, tackle it, whether it's short-term or long-term sickness. And if you do need any assistance with that, I'm more than happy to deal with it, but don't leave it. That's the worst thing you can do. Lots of people come to me when they've got to the point where they want to either dismiss, or the sickness is so high, there's nothing that they feel they can do about it. And basically what needs to happen is, as soon as you identify somebody who's having a lot of sickness, or you're not sure of the reason, or they've gone on long-term sick, is take advice straight away. Don't leave it. Other policies, the Christmas party policy. I don't know how many people will actually be having Christmas parties this year, or even any sort of social event, unless they change the guidance that they've provided. But with anything social, if it is, and I think the key is here, if it's something which is arranged through work, such as the Christmas party, then what happens at that event is still in the course of employment. So I don't know how many Christmas party policies I will be drafting this year, just because of the current climate. But previously, once it starts getting to about this time of year, I do have lots of requests for the Christmas party policy, because usually at the Christmas party there are drinks flowing, people are very relaxed, they say things that they may not ordinarily say in the course of employment, and then people get quite upset, and it can cause lots of issues within the practice. And come January, when we return to work, I get lots of juicy claims about what's actually gone off at the Christmas parties. So a Christmas party policy is something which I do think each practice should have something about social events and what happens at the course of those in those events, and it needs to state things along the lines of ensuring that there's an end time. So if you arrange drinks or a meal, or it may be something low-key this year, or may not be anything at all, but just for future, you must note that everything needs an end time, as in when your liability ends. This came about because of the case where two colleagues went home in a taxi together after the Christmas party. The male colleague made some advances towards their female colleague. She wasn't very happy and made a claim for sexual harassment, and the judge decided that what happened in the back of that taxi was still in the course of employment. So really important that you make it very clear that when the liability ends, when you're no longer responsible for those individuals. Also, don't forget that people have religious and other beliefs in terms of food and drink, if you're providing that, because you don't want to offend people. And it has been found that veganism is a belief. So if you don't provide vegan food, for example, you could end up with a claim for discrimination. So as part of the policy, you want to be asking if there's any special dietary requirements, and if there's anything you can do to assist that. I've just had some questions coming in, so I'm just going to go back to the questions, then we'll look at some more essential policies that you need to have. My principal took over the practice before I started and took over 2 of the girls' contracts. In their contracts, they get 15 days sick pay, and they will take the full amount. How can we tackle this? So not an uncommon situation where if somebody's given an enhanced sick pay, they do make sure that they take it because they see it as an entitlement. You can make changes to terms and conditions, and now is probably one of the best times to be doing it, because even though the principal has taken over the practice and there's this TUPE transfer that we spoke about earlier, there's no timeline on when you can start making changes that are not connected with the sale of the practice. So people will say to me, well, once I've bought the practice, when can I start making changes? And it's like, well, it doesn't work like that, because there's no timeline we don't know. We just have to make sure that as much as possible it's not connected. Now, something like an enhanced sick pay. It may be that now, with the situation being as it is, that the practice maybe isn't making as much money as it could, or it's suffering in other ways, and therefore to take away or change the terms and conditions so that it's not a full sick pay rate that's payable to the staff, you can see that that's got nothing really to do with the sale or the purchase, because it's got everything to do with the current climate. And therefore you'd be okay to do that. And there is a procedure to go through to change terms and conditions. It's quite easy in this climate to be doing changes to terms and conditions. So if somebody has got favourable terms, I'm not saying it's without risk, but what I am saying is that now would be a time to maybe start looking at whether those are right for you in the practice. And if you can't get them on board via agreement, it may be that you look to entice them to provide to drop their 15 days full sick pay, which is an awful lot, I must admit. But it may be that you have to force it to be changed, and there's a procedure to go through. So I'd have no issues in respect of tackling that and helping you deal with that. Most practices don't provide an enhanced sick pay anymore. I appreciate that in some old contracts, and it used to be the case that people were provided with an enhanced rate. But I very rarely come across it nowadays, or people don't ask for it, and most people want it changed, just because of what you said there, in terms of they see it as an entitlement, so they make sure that they take it. So we've had another question. Is it then possible to change hours, days in a new contract for a TUPE'd employee? Thank you. It is, and it's a similar situation that I've just spoken about. So if you're looking at changing terms and conditions, whether they've TUPE'd or not, there is ways and means of going about it, but it is possible. I'm not saying it's without risk, but the risk is it can be diminished if you take advice and take the right steps in respect of taking changing terms and conditions. I've just got another query which kind of fits here, because it's a little bit about sickness absence. Evening, Sarah. We have a nurse absent due to illness, probably a cold, but she has a continuous cough. Does she need a negative COVID test before returning to work? The practice manager seems to think not, as she had a blocked nose, sore throat, cold symptoms, but due to cough, should she have a COVID test? Yeah, I would say, on the safe side, I think she should go and get a test, because none of the symptoms for COVID, from my understanding, is that you have a blocked nose. But I think because of the continuous dry cough, and it's dry cough it tends to be, then it's just peace of mind to go and get a test. I know they're hard to get hold of in some regions, but I would be tempted to definitely ask her to go and get a test, to make sure that you've done everything you can to provide a safe working environment for the rest of the team, but also for your patients. So I think belt and braces approach is better, rather than you or your practice manager trying to be the doctor, because I don't think neither of us are qualified to say whether that's the case. And the last thing you want to do is have knowledge that she had this cough, and yet you still allowed her to come into work, I think that could cause problems. And I don't know if it would be a strong enough defence to say, well, she had a sore throat and a runny nose, so I didn't think it was COVID, because I think the first thing you would be asked is, well, you're not qualified to say whether it is or not. So belt and braces approach, I would advise to go and get a COVID test. And then someone else has just said, if it helps, my nurse just had a headache and sore throat last week and has tested positive. So I think that proves the case that the best thing to do if there's any symptoms that are related to COVID is to encourage the employee to go and get a test. Back to the HR essentials. One of the things that you will definitely need in your staff handbook is a flexible working request policy, and it is worrying me a little bit at the moment because we've had furlough, we've had flexi furlough, and now we've got the job support scheme, and hours have been all over the place, and we've wanted the staff to be flexible, we wanted to change their hours, but actually now I've seen a turn where quite often the staff are now saying, I want these hours, or this suits me better because of childcare. And so many people are just rejecting that request outright and saying no, and not going through a flexible working request. So one of your HR essentials will be your flexible working policy, because every time somebody asks you to change their hours, whether it's number of hours or number of days or to work from home, that actually is a flexible working request. And if you fail to go through a proper procedure and reject that request for the right reasons, if you can't allow it or can't come to a compromise, again, we can end up with an employment tribunal claim. And I just feel, because of the times we're in at the moment, and because we've all tried to be flexible and we've had so much to worry about, this has gone out of the window. And I'm dealing with lots of people who haven't identified that there's been a flexible working request, said no, and then they're ending up with claims in the tribunal because, or the threat of a claim into the employment tribunal, because they've said no and haven't realised that that request is for childcare issues, for example, and therefore it can be sex discrimination that's claimed. And the discrimination claims that are made in the tribunal are unlimited amount of compensation. To give you an idea, there was a case remedy hearing that was finalised last Friday, and it was against Jaguar Land Rover. And what happened is, in that case, is that they had an engineer who had started their employment as a man, and in 2017 had become a woman and had asked to be referred to as Mrs. And they hadn't done this, and there was some issues and things were said in the factory. He raised a grievance, and the employer wasn't very sensitive about it, and the individual ended up resigning, and the Land Rover wouldn't take him back, and at the end of the day the person involved was distraught and felt as though they needed to go and make an employment tribunal claim, and they won their case because gender reassignment is a protected characteristic under the discrimination legislation. And we found out on Friday that that individual was awarded £180,000. So discrimination cases, they are eye-watering amounts of money where they are awarded, and something like this, where you don't identify a flexible working request, is concerning me, how many cases I'm seeing at the moment in respect of this. So I advise that you have a flexible working request application form, and if anybody approaches you as a manager or employer and says, I'd like to change my terms and conditions in respect of my hours or my days, you provide them with this form, you get them to fill it in, and as soon as it's completed and returned to you, the flexible working request procedure starts. And it's so important then that you do that. Don't worry, I know you haven't got a lot of time on your hands, but it's not as though the employee can keep making requests time and time again. They're only allowed to make one every 12 months. So you'll only have to go through this procedure with the individual once after 12 months. And they have to be in employment for at least 26 weeks initially. So please make sure that you identify and have that procedure in place. Another policy that you will be expected to have is the recruitment policy. And this is something that quite often CQC ask that you've got in place, and this again is to prevent any discrimination or any judgment in the workplace. And there are lots of practices out there that are looking to recruit at the moment, it's because time is of the essence, that people are cutting corners, not going through the full procedures, but we need to remember these HR essentials, and I understand why you're doing that, but it's so important that you go through a proper recruitment process when you're looking to recruit, and that's for your self-employed staff as well. There seems to be, people don't understand that self-employed are also covered by the discrimination legislation. So do make sure that you are covered in respect of your self-employed and your employees in terms of recruitment and discrimination. So I've had a question come in. If we have a pregnant team member and her husband is a general manager and thinks he's a HR specialist, we have been really supported her and done all risk assessments. However, she made a comment to the team that they better be careful because my husband knows all about HR. This was the response to our request, that phones are answered in 3 to 4 rings. She sat in front of the phone in a way. So do we deal with her attitude, or can we bring her attention that we're aware that she said this and why? Well, I hear that a lot actually, in terms of I know somebody who knows HR and I know somebody who knows what they're doing, and mostly it's a quick Google, isn't it, for them. They don't really know what they're doing anyway. In those circumstances, if you're concerned about it, and at the end of the day, I assume she does have an issue, I would be tempted to maybe have a conversation with her. And let's face it, we should be having conversations with our staff members anyway. So if we sit down with them once a week or once a month, whatever it may be, I'd maybe bring it up in these support and supervision environment and say very carefully, we understand you've made some comments that suggest that you're not very happy. Is everything all right? Is there anything we can help you with? I wouldn't get into a tit for tat in terms of, we've heard you've said this, we know you've said this, and what do you mean by that? Because it's almost, you're better off just leaving it if you're going to go down that route. But I think if you are slightly concerned that she's unhappy at work, I would do it in that way. So I would invite them in for a meeting and just say, is everything okay? We've heard, we understand, and it may just be a bit of gossip that some comments have been made. Is there anything we can be doing to assist? And I'd be all supportive and try and help, show that you're trying to help them in the first instance before you go down any route. But I wouldn't be concerned at all that the comments being made that they're a HR specialist, because most people think they are. I have a self-employed hygienist who wants to change her hours. Will I need to go through the flexible working request like I would for an employed person? So no, you wouldn't. And I actually, in those circumstances, I would say stay away from doing anything in respect of a flexible working request. Because if you start treating a self-employed staff, member of staff, like an employee, then it's easier for them to claim that they are an employee. So self-employed hygienist, no, you wouldn't go through a flexible working request with them. But you do need to be careful, because, as I said, the self-employed staff are covered by the discrimination legislation. So you just have to understand the reason why they are wanting to change their hours. Which, thank you for that question, because it does lead me on nicely to my next HR essential, which is self-employed agreements. Again, we don't tend to come across people keeping these up to date and making sure that we actually have them in place. If you do not have a self-employed agreement in place, it will be very likely that that individual can claim that they're an employee. And if they can claim that they are an employee, they get lots and lots of rights under the legislation. The main one being, for example, unfair dismissal. So if you have a self-employed associate who has been with you for more than 3 years, and you don't have a contract in place, and you decide you no longer need that associate, and you serve them 3 months industry standard notice to bring their associateship to an end, they may not be very happy about it. They may go and see a solicitor, and it may be that the solicitor says, well, you've got no contract in place. The way you've been treated suggests that you're an employee, and that being the case, you can claim unfair dismissal because there's been no procedure and no reason for your dismissal, and you can be awarded up to £88,000 in the employment tribunal. So the mechanism of a licence fee in the agreements is what makes an individual self-employed. We talk about how much are the associates paid, 50%. Actually, what the agreement says is that the associate pays the practice owner a licence fee of 50% for the use of the equipment, the chair, the surgery, etc. So it's really important that we have that licence fee mechanism. And quite often, self-employed hygienist and therapist agreements don't include that licence fee, and they're more at risk of being an employee. Because to pay an hourly rate, for example, and not have that licence fee mechanism is reflective of an employee situation. If an individual is found to be an employee, there's not only an employment tribunal, but there is also the tax implications. So in your self-employed agreements, you must ensure that there is a tax indemnity clause. This clause means that if the HMRC ever came knocking because they believed that the individuals were employed rather than self-employed, this clause in the contract means that you would be able to share the burden of that with the associate, because HMRC come to the practice, not the associate, to pay back the back tax that should have been paid. At the moment, with the NHS payments that are being paid, HMRC have said that they will turn a blind eye to it, and they do not see that as being one of the indicators of employee status for dental associates. That is not the same in the employment tribunal. So everybody thinks, oh, it's wonderful, they've turned a blind eye to it. HMRC have, not the employment tribunal. So you still have a risk in the employment tribunal with the ways that associates are being paid at the moment, which is quite concerning for a lot of people, because you're being told to pay the associates and self-employed staff in this way. So you know, it's not easy, but anything you can do which is reflective of self-employed status, the better. And one of those conditions that I would say is make sure that you have locum clauses and the ability for the individual to substitute. Again, I worry about hygienists and therapists because it doesn't tend to happen in practice, but you must have these clauses in there, because this is one of the main indicators of self-employed status. So I'm an employee, I can't send somebody in next week to do my job. If you're self-employed, you can, and you should be able to. There is a case a few years old now, and it included a dental associate who had been with IDH for over 6 years, and they terminated his associateship. And he wasn't very happy, and he went to tribunal and claimed unfair dismissal. And he did have a written contract in place, which was great. The judge was going through it, and one of the clauses that the judge looked at was the locum clause. And he said to the associate, have you ever put a locum in place? And he said, no. And he said, well, on that basis, this is a sham agreement, and therefore I find you to be an employee. And that you can, he was found to be unfairly dismissed, and he was awarded £66,000 at tribunal. So when I talk about a locum or a substitute, even though you may have that clause in the agreement, you must also ensure that you exercise that clause in practice. And I've just had a question come through, and it says, hi Sarah, for the locum clause, can you stipulate mutually agreeable? Yeah, I have no issues with that. People, as a practice owner, you don't always like to lose control, so you don't like your associate to be able to go off and source whoever they like. You want to know who's in your practice and do the checks and make sure it's right for you. And quite often I draft clauses where we put the locum clause in there, but we identify that a locum could be somebody else in the practice, so another associate picking up that work, or you can charge the associate for you as practice owner putting a locum in place as well. So don't believe that just because you may have downloaded a contract from somewhere or you've been given a precedent contract that's the law and that's what you have to do. That isn't the case. It will vary from practice to practice as to what is right for you, and there's lots of different ways in which we can ensure that the locum clause suits you in your practice. What do we pay our self-employed associates for sick pay if they are receiving a 1/12 average UDA fairly? Normally, absolutely nothing, because they're on sick and they are self-employed. So if you're sick, you shouldn't be paid anything. If you don't go to work, you don't get paid. In these circumstances, it will depend on how you have decided to pay your associates in terms of the guidance that was provided, where it said you must pay them on the same basis that you paid them last year. So it will depend on how you've decided to pay them going forward. What if we've provided a self-employed contract, but she's just delayed signing it? Would she still be considered employed? I have sent a number of emails to ask her to return the contract, but she generally is just really useless for paperwork. There is case law and there's law to suggest that if you give a contract to somebody and they don't dispute the contract but fail to sign it, it's implied that they actually accept the position. So if in those circumstances, belt and braces approach, try and get the contract signed and back, because there'll be certain clauses that you won't be able to exercise if you don't have them signed, such as restrictions, retentions. But generally in those circumstances, it would be deemed that that contract had been accepted. I'm cautious of the time, but I've got a few more questions, so I'm just going to try and get through a few more. I have a question about liability insurance. If an employee has a fallout with a self-employed staff member and the employee resigns and raises the grievance, but an external mediator from our HR finds unsubstantiated, would this employee have a case if goes to tribunal? The issue with the tribunal is that you do find that quite often you can have a lot of claims that are made in the hope that they get some kind of commercial payout. So if you do have insurance for it, they will deal with it and pay any legal fees and make any out of court settlement or any judgment in it for you, even if the case has a lack of merit. And that's because quite often it's worth commercially making a payment at the outset, because legal fees can be incredibly expensive and you don't get those legal fees back unless you've been in very limited circumstances where you get awarded costs. So if I told you that the average employment tribunal legal fees was somewhere between £15,000 and £30,000 to go all the way to final hearing, yet an individual would walk away with £4,000, you would pay the £4,000 because it would save you a lot of money in the long run. So if you've got insurance, that can help, because insurance will cover any legal fees, and I do advise that this is something that most practices should take out. Definitely something that you should be doing, but whether somebody's got a good case or not doesn't really prevent somebody from making a tribunal claim, because I do see quite often that claims are made even though they have a complete lack of merit, and then you're having to deal with it, and it can be quite stressful and quite time consuming. So in respect of the tribunal claim and the cost, if you've got legal expenses insurance, by the way, and just to clarify, that's not your dental indemnity, it's an extra insurance. It's legal expenses insurance that cover employment tribunal claims, and the claim, even if the receptionist had an issue with the dental associate, would be made against you as her employer, because the liability for her employment rests with yourself. So all employers need to ensure that they have legal expenses insurance. There are quite a few questions left in respect of associates and the current situation with NHS pay, and we will deal with this in a future webinar. And today was really about practice management and HR essentials. And I hope that you can take away from it that today your HR essentials need to be your employment contract, your staff handbook and your self-employed agreements, which, if you haven't had them updated since April this year, they will need to be updated. And don't forget that as part of that staff handbook, and I appreciate it's busy and it's quite awkward times at the moment, but don't forget those policies in those staff handbook, because it would be really, really useful for you to remind yourself of them. So when you are being bombarded with flexible working requests or looking at sickness or recruitment, that you've reminded yourself of those policies. If you do need any assistance, and I haven't answered your query today, or you need more information in respect of it, you can contact me. My email address, I will quickly type it, into the chat box for you so that you've got that information available. And thank you so much. Hopefully I'll see you in 2 weeks, where we'll have another webinar on trying to assist you in practice. So thank you so much for joining me tonight, and I hope you enjoy the rest of your evening. Take care. Thank you.